So today we're going to talk about library contracting, and as always, the first thing that I need to do is show my disclaimer here. Okay, so although many of you know, I have a master's degree in library science and a law degree, but I am not licensed to practice law in Michigan. I cannot, and even if I were, I could not be your library's attorney working for the state. So my information is really meant as general information for you and your library to assist you in making decisions. It is not intended to be legal advice. If you need legal advice, you really need to consult with your attorney. If you're having a hard time locating an attorney, or if you don't currently have an attorney, you can shoot me an email, and I do maintain a list of practitioners in the state that specialize or that work with libraries and do library law, and I'd be happy to share that at any time. Okay. So if you have any questions, so the topics we're going to talk about today concerning contracting are going to bring in some issues involving state aid and penal fines, because very often contracts for service between libraries and municipalities involve state aid and penal fines. And also when we calculate state aid and penal fines for libraries, that's all based on per capita or population. So the amount of people you serve is very important as far as getting the correct state aid amount. So I have Kathy Webb, who is the state aid and penal fine coordinator. She's the person who makes sure that everybody gets their checks for state aid, and that everybody gets, that all of the counties know the correct amount for penal fines for everybody to get. So she's a very important, great person to know, and she's a really great person anyway. So there's her contact information. And then Joe Hamlin, who works with Kathy Webb he does data, but he also does certification, which is another component of state aid. And as far as contracting goes, he also can run reports on which municipalities are currently contracting with who. Then there's me, and I'm the law consultant, as I mentioned, and I can help you with some of the legal aspects of contracting and kind of hints and what to look for. I can also provide you with some sample contracts so you can see what different contracts look like. So those are some contacts for this topic if you need some help. So let's start by looking at what is a contract. Now that may seem kind of, obvious. Everybody knows what a contract is, but, from a legal perspective, there is a, as always, law has to make things a little more complicated. So under the law, a contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law is some way recognizes as a duty. Now, this quote-unquote authoritative definition is from a legal source called the Restatement of Contracts. Restatements come from common law, which is case law. So this is an accepted definition as stated in various cases that over the years have been used as precedent. So essentially what this is saying is that a contract is a set of promises which, if they're accepted, then the promises become a duty to complete. And if you don't complete them, then you're in breach of the contract or you violated the contract. Essentially, contracts are promises. Now we're going to get a little bit more into that in a minute, but for now, a contract is a promise between two or more entities. It can be people, can be companies. And you may not realize, but you enter into more contracts even just in your personal life than you may even know. When you log on to your favorite social media sites, when you created your usernames and passwords, you entered into a contract. When you use the services, often you're in a user agreement, which is a contract. When you use your credit cards, it's a contract. So there's multiple contracts that you enter into every day. There's also, even verbal contracts. You promise your kids something, then technically that could be a contract. So as far as libraries are concerned, the typical contracts are things like your library card application is a contract. So I encourage, I know this is a very busy time of year with summer reading coming up. So this might not be the best time of year to do this, but when you, at the point in the year that maybe things slow down a little bit, and some of you may be laughing about that, but reviewing things like policies and library card contracts is something that every library should do on a regular basis. So when you review those types of things, you may want to take a look at your library card form, because that is a contract between the library and your patron. And you may want to take a look at it with an eye towards, can we modernize it, or can we improve it at all to make it work better, not only for the patron, but for us too. So things like if you want to make it clear that a child's patron record can be viewed by a parent. If the parent's responsible for the fee, you can, make that on your library contract. If you want to add the availability of alternate people to access someone's library record, for example, if you have disabled patrons or patrons who have guardians, either because they're elderly or because they have some kind of disability or because they're very young, you may want to put a checkbox on there is there anyone who can view this record other than the person responsible? And have a checkbox that someone can check, and then write in the names of the people who have permission to check books out or to view this record. So that, for example, if you have a nanny who might check books out for kids, or you have a caregiver for a parent, an old elderly parent, or a disabled person who may want to check out books for that person. If you have a disabled adult, which I do get questions about, and that disabled adult maybe is not always able to come to the library, or has difficulties with communication, or may have a disability that limits their developmental capacity, then you may want to make sure that a guardian and, in addition, perhaps a caregiver have the ability to check out books. And there may be some other tweaks you want to make to it. So I recommend that as with every contract, you would want to take a look at your library card applications once in a while and see if there's anything you need to add or maybe rephrase. Employment contracts. Any directors listening right now on this webinar, chances are you have employment contracts. Employment contracts can be very sticky, because an employment contract is one of those things that can very easily be written. It can be a combination of written and oral. If you promise your employees something and they rely on that promise, then there is a possibility that that could be interpreted as a contract. So employment contracts can be a little sticky, but it's always important to definitely read your employment contract. And when you're hiring, it's important to pay attention to things like if you have an employee handbook. It's important to make sure that you take a look at that every so often and make sure that is also current. And as always, confer with your attorney to make sure that you're not inadvertently making promises or maybe causing some inadvertent consequences, unintended consequences that could affect, say, the library's ability to be an at-will employer. Then, of course, there's licenses. So you have, the contracts you sign for online sources, and for maybe renting movies, and for Wi-Fi service, and for a myriad of things that different libraries obtain. Many of those licenses are kind of what we call boilerplate, which means the word boilerplate just means it's a kind of a copy. It's like standard language that is in wide use. And a lot of contracts are made by law firms or attorneys where they just cut and paste clauses from one into another similar contract. Now, it's easy, attorneys can do that because they understand the ramifications of all these clauses, but as we're going to talk about a little bit later, you want to be careful about doing that. But boilerplate licenses can be some of the most boring, dreadful things to read. In many of my jobs, earlier jobs where I worked in academia, one of my jobs was to review licenses and negotiate contracts for services for the library. And oh my goodness, some of these licenses just are insane with the language. But it's very important to read them, even though they can be very monotonous and boring, because some of the things that, and we're going to talk about this in a minute, there are certain key things that you want to keep an eye out for, and the more of them you read and the more you know what things you keep an eye out for, the easier it gets. Then there's repair and construction or other kinds of service contracts that the library may enter into for things like plumbing or electrical work, or if you're building an addition, or all kinds of those kinds of often day-to-day type things, cleaning contracts. There's programming contracts that you may have with performers or with entities coming in to perform a service for your library. And those sometimes could be slightly different types of contracts. And then there's the big one, which is library services contracts. And those are the ones that most of you probably are the types of ones that you actually maybe create, as opposed to a contract you're handed to sign. So service contracts are where libraries have the ability to contract with municipalities to provide services to those populations. So let's look, and we're going to talk a little bit more about those also in a few minutes. So let's talk a little bit about contracts law triage. So let's look at the components of a legal contract, because even though a contract seems very basic, it's a promise. There are, law over the years has had to, make it complicated. There are certain components of contracts that make them valid or invalid. You can have an invalid contract just because two people promise things. There can be other aspects to it that can make that promise maybe not so enforceable. So your basic valid contract, you need to have offer. So that would be, I'm going to give you a library service, for your people. And then and that offer could be, specific. I'm going to give your patrons the ability to check out books and to use our electronic resources and to use mail. They can actually lay out. Then there's consideration. Now the consideration is a fancy legal term for payment. So in other words, it is what is person A going to get if they give person B, or if the offer that A has given is accepted. So consideration is the money, or it doesn't always have to be money, but it is the return that one of the entities in the contract receives in return for performing the service or giving the product. And then you have acceptance, which is the agreement to actually have this contract. If two people don't agree to have a contract, then there's no contract. So acceptance is actually the agreement that, okay, this is a contract. We do have a promise between the two of us, and both of us are going to abide by this agreement. Now, it's important to note on the side that agreement does not always have to be in a signature. There are cases where agreement can be through what's called performance. And so let's say that two people have an agreement where person A is going to watch the children of person B, person B, person A never formally said they would do it. And person B comes by and drops the kids off, and person A takes care of them. Well, then person A is actually performing the contract even though they didn't say they would. And then person B comes back and gives them money, they accept the money, then they've pretty much agreed to the contract even though they never formally said, I'm going to do it, or signed a line. And that's, that's kind of a, just kind of a side note. Most of the time, acceptance, you'd want it to be very, very plain, a signature. And then you have authority, and this is actually a very big one. Two people can promise anything, but if they are not in a position to be able to promise something or to bind themselves or another entity in the contract, then there really is no contract. So for example, your children, a child cannot legally be bound into a contract. So if someone, for example, you have a child who signs a library card and says, yes, I'll be responsible for paying for these items, and then they don't bring back the items, well, the library really can't go after that child because there really is no contract. A child cannot be bound to a contract. The child has no authority to bind themselves into a contract. So the same is true of a library. Of an entity, when you as a director are contracting for your library, it's very important, and most contracts you'll read, there is usually some line that says that the person signing has the authority to bind the entity, the company, the institution into a contract. So what this means is that directors really should be on the same page with their boards as to how much authority the director has to bind the library into a contract. The board definitely has the authority because the board is the recognized governing authority of the library. Okay, that's by statute. So by statute, the board has the authority to bind the library into a contract. However, depending on the type of library, there may even need, and depending on the type of contract, you may even need to get maybe municipal people involved, because the board, depending on the type of library, and this would be very, very few libraries, in contracting may be binding the municipality, and they may not have the ability to do that. So this is one of the hard parts of contracting. And this is, it's kind of like anything in law. Everything is fine until something isn't. So people can sign contracts, and if everybody abides by it, and the fee is paid, and everybody's happy, then there's no problem. So if someone signed and didn't have the authority to bind, doesn't really matter. Everybody performed, everything's all well and good. Well, if you have a contract where now there's a problem, somebody either breaches the contract, or one party's not happy with how the other party performed, or one party doesn't feel the other party lived up to their promises, or whatever the issue is, one of the things that people will look at is authority. Did the person who promised me this have the authority to promise me it? So that's something that you want to make very sure of, is whether whoever is signing the contract for the library to bind the library has the authority to bind the library to that contract. And that is something that is really a discussion between the director and the board. The board would be able to give the director authority to bind, the library in a contract. And then we have meetings of the minds. Meetings of the minds is where, and this kind of gets to more, this is kind of like, this is kind of like authority, and that meeting of the minds pretty much means that, you have two people or two entities or more who get together and say, okay, we're going to have this agreement on X. And one of the components of a valid contract is that during the course of the negotiations of the contract is that the parties who are contracting with each other are all on the same page. They all are kind of on the same page that this is what the contract is for, this is what you're going to give me, this is what I'm going to give you, that everybody understands and everybody is kind of, on board. The problems arise when you may have, say, one person contracting with someone else who is in a position of power way beyond them. So you have, say, I'm trying to think of a good example. You may have let's say a newcomer, like an author who is trying to make a contract with a big publishing company. Well, the publishing company holds all the power. So that's a situation where you have to be very careful that there's a meeting of the minds and there's not coercion and there's not intimidation, and that everybody has, an equal footing in the contract. There's that everybody, the parties to the contract are equal in terms of their seeing eye to eye on what the terms of the contract are and what the expectations are. Now, as far as the meeting of the minds go, what's interesting is that two people can contract for almost anything they want, or two entities, or as long as it's not illegal. Like, you can't contract, to kill somebody, but you can, as long as what you're contracting for is not an illegal act, and or you're not selling drugs, or all that kind of stuff. As long as both people agree to it, then you can have very creative contracts. You just have to make sure that what the terms are comporting with other possible laws that could impact. So boards would have to be careful of things like their fiduciary duty and local municipal laws that may prevent certain things. But by and large, two entities, you can get creative in the terms of the contract and in even the consideration. We spoke a little bit about equal footing. So the writing. So contracts can be oral. So that means two people can have a contract just by speaking with each other. What we used to call a gentleman's agreement on a handshake. But most of the time, it is good business practice to get your contract in writing. And there are certain types of contracts that must be in writing or they're counted as invalid. And most of those contracts are contracts under the Uniform Commercial Code, which most often is for the sale of goods. Which is most often not something the library is going to be so interested in, except for purchase of books and databases and things. But like, say, for services, which would be library service contracts, there is not necessarily, the UCC does not necessarily apply, but it's a very good idea to definitely get it in writing. Things can get very particular under the UCC and under something called the Statute of Frauds, which is a component of contracts. And the Statute of Frauds is what we call the formalities, which is the writings. And that can get into things like exactly what has to be written down, what terms of a contract have to be there. And some of that is just stuff that we don't necessarily need to go into right now. It's just good for you to know that if you have that A, you want to have your contracts written down, and B, be aware that depending on the kind of contract, there may be certain things that must be contained within the contract. And those are things that as you're contracting, you can either consult your attorney, or you can contact me and I can provide you with some examples that would give you, what those parts are. Okay. Let's talk a little bit about when you're reviewing a contract, what are some things you should be looking at? Well, we spoke just about the writing, the formality, and the Statute of Frauds. So there are, there are some requirements. There's not a ton. Unless it's the UCC, and the UCC is a whole other thing I'm not going to get into right now. It mainly has to do with things like I said, sale of goods. Clear language. So this is important. A lot of contracts, and those of you who have read licenses probably already have seen this, but contracts can be very obtuse. So to the extent that's possible, you want to make sure that before you sign any contract that you are clear on what it's telling you. And this is, this sounds stupid, but it's also true that it can be daunting to take a large contract and go through it and then have to ask for clarification. I've been there, I've had to do it. It can be humbling, it can be a pain in the neck, but it's very important, you know, and again, this is scalable. You know, it's directly related to the amount of money that this contract represents and to the importance of this contract. The more important and the larger the sum of money, the more you're going to want to make absolutely sure that you understand every single thing that that contract is requiring both you to do and the opposite person, the person you're contracting with, to do. So you want to make sure that those terms of the contract are very clear. And when I say terms, I mean both the individual words as well as the requirements, the things that, because sometimes the word term is used to mean the requirements of the contract. You also want to know what's exempted. So if you're doing a contract for service and you are, maybe the municipality you're contracting with is not willing to offer you enough money or cannot, you want to exempt certain services. Well, you want to make absolutely sure that it's very clear that here are the services that we're going to provide, here are the services that we are not going to provide, because that can save a lot of trouble later. You want to make sure that the expectations, that everybody involved in this contract understands what the contract is for and what the result of performance is going to be. So what's going to happen when all is said and done and everybody does what they're supposed to do? What is everybody going to end up with? So again, you know, you want to make sure that everybody's on the same page, and that again goes to the meeting of the minds. And you want to make sure you know when is the money due. When does if you are the one receiving the money, you want to make sure that the other entity understands this is when the money is due and this is what will happen if we don't get it. And this is how it is due. One of the issues we have here at the state is that vendors very often have to pay via electronic funds transfer. So no more with the state are people sending checks. And in order to pay with electronic funds, you have to be enrolled in this certain state program. So vendors all have to enroll in this kind of program in order to pay with an electronic check. And if the vendor doesn't know that, then that can affect the timeline of the payment. So it's very important that that's all understood when the contract's being negotiated. So it's incumbent upon the state, whoever is negotiating on the side, you know, on behalf of the state or an estate agency, to say, look, we want your business, but this is how, you know, this is how we pay out. And if we are buying, you know, if you're working with us, then this is how you get paid. So parties, you want to know who is the contract with. So, and again, this may seem obvious, and most of the time it's very clear, but sometimes it's not as clear. You know, companies buy other companies, you have subsidiaries of companies. So again, you want to read very carefully as to who exactly are you contracting with. For example, school, if you're contracting with a school district, okay, are you contracting with an individual school or are you contracting with the entire district? And then you have the start and end date. At what point does performance have to begin? When is the expectation that whoever has to either deliver goods or services, at what point does that have to start? When is that finished? Is there an automatic renewal? A lot of library service contracts traditionally have had automatic renewals. So many of the contracts we have here at the state in our files may be from the 70s or even the 60s and earlier, and they have a clause at the end that says this is automatically renewable until somebody cancels. So, you know, you may have contracts that have been going on since, you know, 1975 or 1980 that are in this boilerplate language. Many of them are photocopied, or we even have a few that are mimeographed. And, obviously the terms are old, the consideration is old. So, this again is an opportunity for you to go through your files and see, okay, do I have municipalities that we've been contracting with forever and my contracts are mimeographed? If you have a mimeographed contract, it's time to take a look at that contract. But you always want to make sure you know the start date, the end date, if it's an automatic renewal. And kind of wrapped into that is if you are contracting for state aid or penal fines, particularly penal fines, you want to keep an eye on that start and end date, because penal fines are distributed based on June 30th of every year. So whoever is serving the population on June 30th is the one who gets the penal fine money. Doesn't matter if a library was serving a population for the entire year. If their contract ends May 31st, then it's whoever picked up the contract on June 1st who gets the penal fine money for the entire previous year. So that is a very important date. So you want to make sure that your contracts for penal fines all include that June 30th date. So you don't want to switch a contract, you don't want to end a contract before June 30th, and you don't want to start a contract after June 30th. So that's important. Or as close, you want to make sure that you capture that June 30th date. You want to make sure that there is a termination clause in your contract, because if there isn't, then that means it's going to be very hard to get out of it. And it's going to be very unclear how the contract can be ended before the end date. So you want to make sure that every contract you get into has some kind of termination, that whether there is a 6-month or maybe a penalty involved for early termination, and that's okay, but you always want to make sure there's like an escape clause, that just because you never know what might happen. Modification. Can your contract be amended? If you're signing a contract for, services and, you don't know what's going to happen in the next year, right? So what if your library becomes flooded, or what if there's some other, natural disaster that occurs that might make it difficult for you to continue the contract? Well, you have a possibility of a termination clause, but maybe a modification clause would be appropriate. Maybe you have a millage that you're coming up for, and you don't get it. You may want to consider, if you're very concerned about that, then you may want to consider the ability to modify a contract, so that you say, well, it looks like we might not get this millage. Or if you don't get the millage, you have the ability to modify your contract to say, okay, well, we didn't get a millage, we can't afford this, we may need to ask for some more money from another municipality or whatever. And of course, you want to make sure that there is some kind of consideration, or it's not a valid contract, and that there is acceptance in the form of an approved authoritative signature, correct? You want to make sure that you definitely have a signature of someone who can bind the entity that you're contracting with. So if you're contracting with a municipality, make sure that the person who signs the contract is someone who has the ability to bind the municipality. And you may say, well, how do I know that? Well, anybody from the governing board of that municipality. So if you have the mayor, of course, or the township supervisor, those are the kind of entities that you most likely want to deal with. So when you're talking about library service contracts, the establishment acts of every library type in Michigan and different municipal laws provide libraries and municipalities with permission to contract with each other. So, in that, those laws form some of the authority for libraries to contract. Now, let's say you want to do a library service contract, and you've checked your library establishment law and it says, yes, you can contract with a municipality. Now, I want to step back a minute and talk about contracting with municipalities. It's important to note that there are laws that say municipalities can contract with municipalities. So when you're, depending on your establishment type, okay, so if you are, say, a charter township library, or you are a PA 164 Section 1 city library, and those are two establishment types where your municipalities may be very involved in your operation of your library. Municipalities can, and districts also, district libraries that are formed by municipalities, and municipalities can amend their district library agreements. Municipalities can contract with other municipalities. And that's a right that the legislature has given municipalities. And there's nothing in those laws that limit what they can necessarily contract for. So for example, there's nothing that says that two municipalities can't contract about their library, but without consulting the library. Now that sounds kind of stupid and scary, but you would hope that that wouldn't happen with certain establishment types. The important thing to note is that an agreement between two municipalities may be valid, but there may be issues again with state aid and penal fines, because there may be other laws in play or other requirements in play that, say, for example, require municipalities to provide those agreements to the Library of Michigan in order to get penal fines and state aid. So, sometimes it is important to note that municipalities do have the ability to contract with each other, but that if they don't comply with the requirements, as far as their library contracts go, as far as if there is a requirement to provide the copy of the agreement to the library, then that could affect their penal fines and state aid. It also could affect that a municipality may not be able to bind the library board into performance. So in 99% of establishment types in Michigan, two municipalities having an agreement would not affect the library, even if they're trying to contract about the library, because they do not have the ability to bind the library board without the library board's participation. So there's been a couple questions about that, so I just wanted to mention it. Okay, so when you're trying to do service contracts for, you want to provide service, many of the times that this occurs is because libraries have a specific population in mind. They know of an unserved area that they want to serve. But we also have some libraries who ask us, look, we are looking to see if we can find populations. We'd like to enter into contracts, and we just don't know where those populations are. The Library of Michigan maintains a list of unserved populations. So, and this is one of the things that Kathy Webb and Joe do. They maintain a list of, and primarily this is Kathy Webb, they maintain a list of all of the municipalities and the populations in the state that are currently unserved by libraries. That means they are currently not involved in a contract for library service, and they are currently not part of a legal service area that is an existing library. And we have many. I have on this slide just a screenshot of the beginning of the report. The report is alphabetical by municipality, but it gives you the cooperative, it gives you the county, and it gives you the percent of the population that is involved. So for example, on this screenshot here, it looks like we have Adams Township, 100% of the population is currently unserved, and that's 2,573 people in Houghton County. So a library that's up in Houghton County may be interested in approaching that township to see if they'd be interested in getting library service and in a contract for library service. So if you're interested, I can supply you with a copy of this list, and you can look at it and see if there is geographically different partners that you may be near you that you don't realize that you could contract with. Some other things to look at would be your current visitors. Do you have a lot of non-resident users? If you have a lot of non-resident users, you may want to see where they're from, and you may want to approach that municipality. Now, there are situations where non-resident users, people who purchase non-resident cards, may be from areas that are served by libraries. There's quite a few areas in the state where the populations kind of service kind of gets like a Venn diagram. It kind of gets merged. So you may have two libraries not far from each other, and even though the legal service areas of those libraries are distinct, the populations don't know legal service areas, and populations are going to go to the library that they want to go to if they're permitted. And if they need to buy a non-residency card, if they really love the library, that's what they're going to do. So you may have patrons that have non-residency cards that are legal service populations of another library. If you're finding that you serve a large quantity of a population from an area that is served by a library, well, you may want to go and talk to that other library, because they may be serving part of your population. And there are libraries in this state that have, say, shared agreements for penal fines and state aid, that have, some really interesting cooperative type agreements that may be mutually beneficial, and that reflect the reality of their service. So, that's, one option you could look at. It also may be, we have other areas in the state where large quantities of people are buying non-residency cards because they don't have library service. And if that's the situation, you may want to do a kind of a cost-benefit analysis and say, okay, well, if we were to get this whole population of this township next to us where they're using our library, and yeah, they're buying non-residency cards, but we have maybe 100 families who buy non-residency cards for $100 a piece, but this is a population of 2,000 people. What would be the state aid and penal fines that we could get, and would there be a possibility that we could contract with them for additional funds, and then thereby kind of, it would almost be as if everybody bought a non-residency card, and then we're serving everybody and we're maybe making more money. Your neighbors. If there are, by looking at this list, you see, gee, I didn't realize that municipality was unserved. So there's, there are, and in some areas you just know, like everybody knows, well, that township is unserved. And there's many, many reasons why an area is unserved. It could be that they can't get a millage passed. It may be that there's some baggage there, and there's some history, and there's politics, or there's a whole bunch of things. But maybe they're just looking for the right option. Maybe they're just looking for the right library to come up and ask them. So again, if you're interested in that, I'd be happy to supply that. I see that I have looks like I have a couple questions. Let me quickly see if I can look at the chat and see. Oh, okay. I see somebody has asked for a copy of the report. You know what I'll do? I will go ahead, when I send out the link to the recording here, I will just go ahead and send it out to everybody. So I'll make sure everybody gets a copy of the current report. As part of, I'll just send it to everybody who's registered for this webinar. So that, it seems to me, maybe that might be a good idea. It is kind of a handy thing to have. Okay, so let's now talk about options for contracting. So now everybody has kind of a little bit of idea of what constitutes a contract, what types of contracts. Let's really kind of knuckle down into library service contracts, and let's look at some options. And this again is another question that I get a lot. So the basic library service contract that has been in effect, like the traditional one that many older contracts still abide by, is full library service in return for penal fines and state aid, period. Now, many of you realize that that just ends up not being enough money. So in library land, the funding of penal fines and state aid is done on a per capita amount, right? So what happens is Kathy Webb here gets census information from Treasury, and that would be the 2010 census, population records, that's the official numbers we use. So those 2010 population records then are multiplied by the amount of the per capita state aid and the per capita penal fines, and that's what's used to give you your money. If you have contracts, then Kathy adds the populations of those municipalities to your legal service population in order to get your full population. Now, as time has gone on, there can be quite a lot of contention in different areas where you have a legal service area that's paying a millage and is representing for penal fines and state aid, and then you have a contracted area for the same library that's only contributing penal fines and state aid. So, if you're a member legal service area and you're paying, $35 to $100 a year in taxes to support this library, and then, your neighbor from another municipality is using the same library and the same services, and they're paying nothing out of pocket, they're only, it's the state aid and penal fines, then there can be some contention there. And if that gets around, there has been incidents of, people get very angry. And then the library is kind of stuck in the middle. So one of the things that is becoming more and more common now is when people are negotiating contracts, when libraries are negotiating contracts with municipalities for service, they will say, so penal fines and state aid plus we have calculated what the difference is between, so what they'll do, backtrack a minute, is for their legal service area, and Kathy Webb can help you with this, they will take their millage amount plus the penal fines and state aid per capita, and they will add that together. So let's say if you pay $100 a year in taxes for your millage, for your library, and then your penal fine is about, let's say, 50 cents per capita. That's kind of high, but I'm just going to say it's 50 cents. And then your state aid's about, 30 cents. So that's 80 cents plus 100. So $100.80. So you can then take that and tell the municipality, okay, we want per person in your municipality, we want you to pay $100 per person in your municipality in order to receive full library service. And it's a difficult argument for the other municipality to push against, because you're saying, okay, this is what our residents pay for library service. We want your residents to pay the same amount. So again, it's an equal footing. It's a meeting of the minds. This is what they pay for this same thing. You have to pay the same thing, because we can't have different populations getting the same service for different amounts of money. And that's becoming more and more common. Some municipalities do it, some municipalities don't, but it's becoming an easier and easier sell because the municipalities recognize, it's like I said, it's a hard argument to fight against. The other option you can do, as far as a negotiating tool, is you can start looking at your library services and you can ratchet them down and say, okay, so if your municipality can't afford this, then we're going to permit, we'll say, okay, let's give you just basic library service for penal fines and state aid. In order to receive penal fines, you have to offer library service. So if you're going to take penal fines from a municipality, you have to offer them basic service. That's part of the Constitution. So what's basic service? So that would be, being able to check books out, being able to come in and use the library and use computer, those kind of very basic level 1 type services. Things like the ability to use Overdrive or the ability to access certain things remotely via your library card or ebooks or certain other things are not part of that basic service. So we have several libraries that contract on the basis of, okay, the municipalities get basic services for penal fines and state aid if individual members of that community want better service, they want full service, then those individual members can then themselves pay out of pocket for this increased service by purchasing a discounted non-residency card. And again, because you are receiving state aid and penal fines, you can't just say you have to buy a full-on out-of-residency card. You have to create kind of a new class of residency card cost and say, okay, we're going to give you a discounted rate on a residency card, and then that cost combined with the penal fines and state aid will put you on an equal footing with members of our community who also share those privileges. So there are things that you can do if you have a community that you'd like to serve, but either they're unwilling or they can't afford to foot the bill in the same way that your community does. The other thing, of course, you can do is require them to get a millage. Now, one of the things to watch out for in terms of requiring a millage may be that that community may then ask for a seat on your board. And it is not unheard of for some contracted communities to have seats on boards. Again, contracts can be very fluid. And the community, when you're in terms of library establishment, it would be possible for a municipality to delegate one of their seats to an incoming community or a contract community. So there's a wide range of possibilities there. That's, we encourage you to think creatively, but again, you want to make absolutely sure that your creative ideas do comport with existing laws. And that's, again, something we can help you. If you have an idea, you can talk to your attorney about it. You can send it to me and I can do some research and send you what I find. And, you always, in the end, want to talk to your attorney in terms of actually drafting language. So when you're looking at contracts, service contracts, and as well as almost just pretty much any contract you deal with, you want to make sure that, you ask yourself, does the library board have the authority to enter into this contract, or does the director have the authority to enter into this contract, to bind the library into this? If you are, depending on your establishment type, you may have to look at, does your municipality have to be involved in this? If so, if you do have the ability to bind, then do the aspects of this contract require looking into other laws in Michigan besides library laws? Do you need to look at employment laws? Do you need to look at any constitutional issues? So there may be other things you have to consider. Copyright. Are there any library policies that might impact this contract? So again, you can have the best contract in the world, but if you can't perform it, if the library agrees to do something and then discovers, this is going to create a big problem for our community, or it's going to change the way we do things, excuse me, then that's something else you have to consider. And that all goes into really reading very carefully any proposed contract, reading all of the offer and reading all of the terms of the contract, make sure you understand what the expectations are of the entities you're contracting with, and how those expectations and the performance of those expectations may work with your existing policies and your business model and how you conduct your day-to-day business. Do you know all of the essential terms? Do you really understand what this contract is for and what it's making you do? And what do you want? why is the library entering into this contract? And does this contract accomplish the goals that you want? And as far as negotiation, how much are you willing to part with those goals or to compromise those goals if you need to? So those are things that really, for any contract, you need to kind of look at. As I mentioned, for penal fines and state aid, you have to make absolutely sure that the Kathy Webb knows about the contract, has a copy of the contract, and is really clear on the parties to the contract so that she can make sure that the library is adequately compensated in state aid and penal fines for their contracting populations. And this is also true if you withdraw or you terminate or you cancel a contract. Okay, not doing this can have some really uncomfortable consequences. Okay, if you fail to let us know that you canceled a contract, then you could receive penal fines erroneously, and then you have to figure out how to get them back, how to give them back, and you can have municipalities upset with you. You can be getting state aid incorrectly. If someone else doesn't notify us and then you contract with, someone drops a contract and you pick it up, then if that person doesn't let us know that the contract's been terminated, or you don't let us know that you have a new contract, then you may not get the state aid or penal fines that you expect because we don't know to reallocate the population. And it is not incumbent upon the Library of Michigan to ferret that out. There's absolutely no way that we can possibly know who is contracting with whom unless the libraries tell us. So it's really important that you make sure that you let us know if you mess with your contracts. Okay, oops. I'm gonna go to the next slide. There we go. Read, and this may sound really stupid, but you really have to read. Contracts are about words, and it's boring as heck, but it's really important. Even I have a hard time reading some of these licenses, and sometimes I have to put them away and go back to them. But it's really important, and you can just get a highlighter and highlight things as you go, and that can kind of help. There's a famous contract between Van Halen and where they used to require that you could not have brown M&Ms, and I have that clause here at the bottom of the screen. And the reason for that, people for a lot of years it was held up as like the excesses of rock bands and how crazy they are, but in reality the reason behind that clause was not because they were weird rockers, which maybe they were, but it was because when they were touring and when they got very popular, they would play some smaller venues that didn't have the structural integrity to handle the weight of some of their equipment. And so their contract was very heavy with a lot of technical requirements. And they used this brown M&M as a way to gauge whether or not the venue really read the contract. So they knew if they got a bowl of M&Ms with no brown ones, then that was probably a pretty safe venue and they would probably be okay. If they didn't, if their bowl of M&Ms had brown ones in it, then they knew they had to really double check all of their technical requirements. So that's kind of just a humorous but little lesson in making sure that there is a real importance to making sure you read every contract. Maybe not as important as your technical requirements of something falling through a stage, but it can have some serious ramifications. And there's another amusing one there from Tumblr. That's something they slipped into their user agreement. So this contract here is just an example that has some flaws in it. I'm gonna let you, because our webinar is gonna end, I am gonna let you figure out what's wrong there. And then this is the end. So thank you very much. I appreciate everyone being here. I don't want you guys to get kind of cut off. So I will be sending a copy of the links to everybody, to the recording, as well as the slides, and as well as a copy of the list of unserved areas. Thank you everybody for being on this webinar, and I hope you have a great day.